Happy Monday, everyone. This is Rob Ransome again coming to you for a Market Monday. And this one is a little different. I love having people come on and talk about different things. And I've had some inspectors, some all sorts of home people that I've dealt with. And everyone has come on and talked about different things. This one is special because this comes from the post that I had about 5 or 6 weeks ago where I had someone lose a house to foreclosure. And it could have been avoided, was not avoided, but I started talking about estates and estate planning. And so I decided to come on with Miss Lynn Tucker, who is my estate planner. And I say that because she helped my family get some things in order. And so I figured the best way to do this would be to come to you all with her and just ask her a few questions to at least get the conversation started. And if nothing else, feel free, definitely, I'll have her give her information at the end. She will definitely, and I'll put it in the caption as well. She will definitely answer all of your questions. She will help you from A to Z with your estate planning, and she's great. So first of all, thank you
very much
for joining me today. And as I was saying to everyone a few weeks ago, what happened was I had someone come to me, wanted to sell a house, had a ton of heirs on the house, got the house sold twice actually, had 2 different contracts, and all of the heirs signed, but 2 would not, and it forced the house into foreclosure over a $30,000 mortgage. And so, and I just couldn't believe it because I was trying to figure out what we could have done. And I know we could have done a partition suit. I did talk to Curtis about that. But what are some things to avoid getting to that place is where I wanted to start.
Okay. Do you want me to jump right in with that?
Yeah, sure.
Because I can tell you right now, without even being familiar with that specific transaction, what occurred was no planning, meaning no wills in the course of the people who owned it originally, and then as people died, the lack of wills designating who is to get your property then defaults to Virginia law stating who inherits the interest in the property.
Okay.
So that could be if our original 2 owners, let's say the deed is 75 years old, and there was a husband and wife at the time who owned it, and they had 10 children, which wasn't.
It's 14 in this one.
Yeah, there you go.
Yeah.
So that's what happens. So the second died. So first the husband died. Let's say now the wife owns it 100%. She dies. If she doesn't have a will, then everything goes to her children, and not just her living children. If she had 14 children and 3 of them were deceased, then her estate went into 12 shares. 1/12 would go to the deceased child's children, and maybe that deceased child had 5 children. So now you've already got, without trying to do that,
it's like 17 people right
9
there.
living people, right, and the deceased 3 people, their heirs.
Right.
You've got all these people. Now, they all consider it, mama's house.
Right.
And maybe two or 3 of the family members live there. And maybe while they're living there, they're paying the real estate taxes. And if there's the mortgage, the original mortgage, maybe they're paying that. Then they die or they decide to move out. Nobody really wants to pick up the responsibility to pay the real estate taxes, to keep it insured. They don't want to let go of the property because it's treasured property. But if they can't come together, and the more people you have own it, the less likely they are to come together. That's just the reality of people. We had a situation where we had 34 people eventually that we were able to zoom in are now the owners, and we actually got all of them to sign the deeds and everything for this. So that was a miracle that happened. I recently did one with a family in different branches. There were only 11 of them though. They were cousins, and I met with almost all of them together. They were a wonderful example of a family that they were laughing together. They remembered growing up together and going to family reunions. They all went on the same page as far as selling that property. But it so often happens that it doesn't. And it doesn't necessarily make rational sense that it doesn't. Like the situation you had, it obviously made sense for it to be sold. But those 1 or 2 people, it was the principle of things with them. They had some reason, and I will tell a client who comes to me with that situation, why don't you let me send them a letter that says, this is what's going to happen if everyone can't come together to sell it. it's going to get, someone can petition the court to have it sold.
Right.
It's going to get sold.
Right.
And you're going to get less money than you would have because now the lawyers are going to get a bunch of the money.
Right.
The courts got costs and fees.
Right.
They're going to have it appraised, all these costs.
Right.
So it's so short-sighted not to agree. So sometimes the letter, we'll at least give them a letter. They can take it to their own lawyer to see. And then that lawyer's going to say, yeah, that's right. That's the process. Okay. Then maybe they'd come on board. But otherwise, you can't make them. I tell people, you can't make someone sell their interest unless you go to court. That's the only way to make them do it. Is there is a process in Virginia where the court will order it sold.
Okay.
So that's called the partition suit.
The partition suit, and that's what Curtis mentioned to me.
So if people die with some planning, maybe the person who maybe the 12 children, the initial 12 children or 14 children. Maybe the mother didn't have a will, but we knew who owned it then. Then one of them could say, a simple will, at my death, any interest I have in that property goes to this one person or to my sister or my brother, so keep it in the family. Because what happens without a will, it starts going to spouses. Too.
Right. Okay. Oh, wow. Okay.
Goes to a spouse. A spouse inherits the interest of their husband, and then the spouse remarries.
Oh, wow.
And it can get so off track of even being part of that blood family.
Right.
By not doing the planning.
I had that actually happen one time before as well. I sold a house that did not belong to these kids, but their mom remarried.
Maybe had another child too, and now that child's in the, it really becomes convoluted.
That was a bad situation. So I won't go into that one, but that was a bad situation. Yeah. So I had a few questions, very specific, because I don't want to hold you all day. I know you're busy. The first thing, and I think people get confused with this, is we've dealt with it in our family. What is the difference between an administrator versus an executor?
Okay. So first, a lot of times people believe that if there's a will, there's no probate, and that's not true. So first, let me just say, what is probate? That word.
Okay, yes.
All right. Probate is the process where the court gets involved to appoint somebody to be in charge of someone's estate. And that's needed if there are assets that no one can get to, because if my husband dies and has a stock account with Dominion stock, and he didn't put me on there jointly, or he didn't name me as the beneficiary on the stock, I can't just call Dominion when he dies and say, my husband's died, I'm his sole heir, please turn it over to me. Dominion's going to say, we'll only talk to the court-appointed administrator or executor. So I have to make an appointment with the clerk and qualify in order to open probate and get to those assets.
Gotcha.
So if my husband has a will, I take the will to the probate appointment, and the clerk swears me in as executor because there's a will. I'm called the executor. If my husband did not leave a will, I make the appointment with the probate clerk, and I meet with her, and she or he swears me in as administrator of my husband's estate.
So it's whether or not you have a will.
Yes. With a will, there's an executor. Without a will, it's an administrator. Okay. Either way, probate is that process of getting sworn in that role, so you can then get to the assets that are needed.
Got you.
Right.
Okay. This came up. Someone actually sent this as a question, and I'll ask you in your opinion. What is the better way to pass property to an heir? A will versus a trust? All
right. So, and by property, do we want to talk about mainly real estate?
Let's talk about real estate. Let's keep it to real estate. Yes.
So there are several different ways that real estate can transfer. One is do nothing, and Virginia law says who it goes to, which is if I don't have a will and I die and no one's on the deed with me to get it, if I'm married, it's going to go to my spouse. Unless I have children who are not my spouse's children. In that case, it's going to go to my spouse and my children in certain percentages.
Wow, okay.
If I have no spouse, I'm widowed or divorced, and I have children, it drops straight down to my children. All of my children, or if a child's deceased, to their, my grandchildren. So it stays with my descendants. If I don't have any children either, then it goes up to my parents. If they're not living, it goes to my siblings. So that's how Virginia law sets up our family tree of where our real estate goes. So real estate can pass just by law if we do nothing. Real estate can pass by will. So my will could leave everything I have, including my real estate, to the SPCA. And that's where it goes. The will gets probated, and now the will is like the deed. It's in the courthouse records, and it says the SPCA owns my real estate. The third way is a deed. Of course, I have to sign a deed while I'm living. So at my death, it doesn't transfer by deed unless I do what's called a transfer on death deed,
Well, so
which Virginia adopted that law several years ago. Most states do not have it. They're coming along. There's maybe 5 or 6 states now that have that. They call it different things. Florida calls it a ladybird deed.
Okay.
But in Virginia, we call it a revocable transfer on death deed. I can sign a deed now and record it at the courthouse that says, on my death, the beneficiaries of my property are whoever I want to name. I might name my trust if I want it to go into a trust to control from the grave. I might name my husband. I might name my children. But I record it now while I'm living, and at my death, it transfers directly to those people. So it doesn't go through, quote, the probate process. Because it's avoided probate by being already in the courthouse. So that's another way to transfer property at your death.
And just for those who don't know, so probate is just the process of
getting to
assets,
gather them, and then the court, the part that people don't like about probate is the court has oversight then of the probate process. So if I've been sworn in as either executor or administrator, I have to report to the court what I'm doing. So I have 4 months to report a list of the assets that I've gathered that have come into my hands. Then I've got a year to pay all the bills, distribute that, and I have to
and report back.
I have to do a written account to the court with all the receipts and vouchers, and they audit it. So that's the probate process. If you have a simple estate, it's not going to be a hard thing to do. It's not going to be that difficult. If you have a more complicated estate, real estate in lots of different jurisdictions, money assets that you haven't designated outside of, to people to go directly to them. My job's going to be a little more complex, and I'm going to hire a lawyer or a CPA to help me. So there's those probate costs. So if people want to avoid that, if they want their loved ones to avoid having to go through that, that's when they can do other kinds of planning, like designating a transfer on death beneficiary or doing a trust, a revocable living trust. So a trust can avoid probate. You put your assets in it now while you're living, and at your death, the trust is private. And it says where your assets go.
Interestingly enough, I had a situation where, and this was the first time that I really started realizing how powerful trusts were. This was several years ago. A young lady came to me to sell her deceased father's house. He had it in a trust, but the issue was, and he just told her, whatever happens, when I pass away, do not go to probate, right? The house was in a trust, but the trustee of the trust was the attorney that set it up. And he didn't have another beneficiary or substitute trustee or anything like that. He passed away, and the father's passed away. So now the property's just basically sitting out there. She ended up having to go through probate in order to, they had to back it up and go through probate to establish a chain of title for the property.
I'm not sure exactly what happened in that situation because the trust itself names the trustee. The father would have been the trustee, and then he named who would be his trustee on his death. If that trustee wasn't living, someone else can get appointed by the court trustee. They just petition the court to be appointed as trustee.
Gotcha. Okay.
She would have been an obvious person to do it. I don't know why the court wouldn't have let her unless, you do have to have certain things could disqualify you, like if you had a bankruptcy or a criminal conviction, then the court's going to say, I don't know if we trust you, to handle those assets.
Gotcha.
But they should have been able to get a substitute trustee in there.
That's interesting. They wouldn't let it. Like I said, we ended up having to go back through probate, or she had to schedule probate and all this stuff. We had the house under contract
to get the house out of the trust, and then
and
that's. I'm not sure really what happened. In that
situation, it was a really weird kind of situation that happened. But that's when I first started saying, and I started asking people, so tell me about trust and real estate, and
trust. I do trust all the time, and I rarely have people name professionals because I discourage that, honestly. Tell them, if you've got a family member or a friend who you trust, like you would trust them to be your executor if you were doing a will, name them before you go naming a lawyer or another professional like a bank trust department, because they're going to charge the highest fees they can, and they're probably only going to take it on if there's a substantial amount of assets in there, so they make fees.
That's it, right.
So that's not a good idea, I would say, to name your lawyer. And there are some lawyers who just I see those trusts.
Supposedly that happened to Kobe Bryant's estate, but obviously
that was a bigger. That's a big enough estate. Maybe he felt like it was going to be way too complex for any non-professionals that he knew. But you have to be careful.
Yeah, because that's one thing I've noticed, the difference between California and Virginia. Probably half of the properties that I've dealt with in California are in trusts.
Well, I'll tell you one reason for that. The same is true in Florida. And that's because the probate fees and taxes are so high in those states. Virginia has a relatively cheap probate tax and probate fee system. So people aren't, once they educate themselves on what's going to happen if my estate goes through probate and what are the fees going to be, a lot of times they'll elect not to bother and not to pay the money that it's going to take to do a trust and deed their property to a trust. They'll just be like, it sounds like it won't be too hard a process. I'll just let my heirs deal with that. And that's why, Virginia, the probate tax is $1 per thousand. Okay. So if I have $1 million estate going through probate, that's $1,000 in probate tax. So that's, and we don't have an inheritance tax that, we follow the feds, which right now is like $14 million. So there's no estate tax to worry about. So it's not so much the fees that get people to want to avoid probate as just having to do the accounting for the court. And like I said, it can be, depending on your circumstance, probate can be a simple situation, which is why people will talk to me. Once I know their circumstance, their facts, their goals, I can explain what the probate process would look like, and I'll advise whether we ought to try to maybe avoid it for this reason or that, maybe do a trust or transfer on death deeds. Got you.
Third question. Is it easier to use a transfer on death deed instead of either the more commonly will, trust, or whatever? I know
we kind of addressed that.
Yeah, what you said.
It is easier. Let me tell you a pro and con of the transfer on death deed. The pro is that if my mother had recorded a transfer on death deed of her house, at her death, and that's Henrico, at her death, I take her death certificate up to Henrico, and they'll see, okay, she's passed away, Lynn Tucker is the beneficiary, and they'll update the tax records to show me as the owner. So that was easy. And I didn't have to pay the probate tax on that asset. If it's in my mother's will, she dies, it's in her will, then I make the probate appointment. The clerk's going to say, what's the value of the house? We look up the tax assessment. It's $350,000. She's going to say, okay, pay me $350 probate tax. So I pay the probate tax. We record the will, and now I'm the owner that way. If it's in a trust, I never have to involve the courts at all because my mother had her house in a trust. She named me the trustee. The trust tells me, everything in my trust goes to Lynn, and now, I'll do a deed to myself out of the trust to my name. So those are the different ways it can happen. So there's not really a better or worse, but a downside to that transfer on death deed is if I name my two sons as beneficiaries and one of my sons passes away before I do, and maybe I'm incompetent, so I can't redo the will, the deed, my surviving son gets that property. It doesn't, the half that went to my deceased son doesn't go to his children. Whereas in a will or a trust, if I had it set up in my will or my trust and my will, they're going to say, I leave everything here 50-50 to my two sons. If one of them has predeceased me but has children, his share is going to go to his children. Gotcha. So that's a downside. But if I'm competent, I can update my transfer on death deed. But it's just something that's good to be aware of. Okay, yeah, because you asked that question with my brother and I, with my parents, and obviously he and I are like, we're on the same page. So, but I didn't realize that's what would happen if something were to happen to one of us. Okay. But that's why it's called a revocable transfer on death deed. You can change it anytime. Before you die, you can change that deed. Okay.
This is a big one because I think people feel this, or that they should be able to, and I've run into this quite a few times. Will any of these transfer vehicles, so whether it's a will, trust, transfer on death deed, will any of those just allow you to take over a mortgage?
Okay, I know exactly what you're asking, and let me answer it this way. A mortgage, a default on a mortgage does not include if I die, my heirs now own my property. That is not a default of the mortgage. So the lender can't call the loan. They have to allow my heirs to continue to pay the mortgage. Okay. All right. Okay. So that part's fine. The problem is, one, I've got a lot of heirs and none of them wants to pay the mortgage.
Right.
One is willing to pay the mortgage, but he can't get contribution from the others. So how long is that going to go on?
Right.
Or it could be my children will continue to pay the mortgage, and they're allowed to continue to pay it. The lender cannot foreclose so long as it's being paid.
Okay.
The downside for my heirs is that they're not the borrower. Just because they can pay the mortgage doesn't change the fact that I'm the borrower. The deceased person is on the loan with the bank. So the bank won't talk to my children because they're,
that's what
they're not the borrower. So you can keep paying it, but at the end of the year, you're not going to get that the interest. You're not going to get that interest form from the bank that says you can deduct that on your taxes. You can't. So yes, you can keep paying the mortgage, but it's probably in your best interest to either refinance the mortgage. See, now it's your house. You can get your own loan. So you get a loan, a refinance loan to pay off the mother's mortgage, and just now you're paying your own. Now you can communicate with the bank on it and deduct the interest.
That's okay. That was.
So heirs should either sell it or refinance, and not just keep paying the mortgage.
Right. Okay.
But they can. The bank cannot foreclose as long as they're getting payment. Okay. That's not true of a reverse mortgage. That's a whole different product.
That's a whole different ball game. That's something that I frequently have come into contact with on foreclosure, and this wasn't that particular case, but yes, I have come across that as well.
Because the term of a reverse mortgage is when you die, we get paid back. Right. That's literally the terms of a reverse mortgage, whereas a normal mortgage that we all get, it's a 30-year loan. I get to keep paying it, and my heirs can keep paying it.
Okay. Yeah, so and I asked that question again because I've had people say, well, I'm the executor, I'm the administrator, I should be able to talk to the bank, and blah, 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 but you're not the borrower. And
correct.
So that's
now let me address that real quick though, because you asked early on the difference between an executor and administrator. This is a very important difference when we're talking about a mortgage.
Okay.
An executor who's named in the will, they have authority over real estate. So the bank will communicate with an executor.
Gotcha.
Once the court, just because you're named in the will as execander doesn't make you executor. You have to probate the will and get sworn in. I do this way.
Yeah.
I do that. I'm a hand person. I get sworn in as
it's
executor.
All right.
And the clerk gave me a piece of paper saying I was sworn in. That's what the lender's looking for. As long as they have that protects them that they're talking to the authorized
right person.
An administrator, where there's no will, they have no authority over real estate.
Gotcha.
An administrator can only handle the personal property, the money in the bank, the stuff. That's very frustrating to people who are administrator because they think, oh, now I can sell the property.
Right.
But they cannot. An administrator cannot sell real estate unless they go to court, petition the court, and the court specifically allows them to sell it. So an executor, though, has that authority under the will. So that's a difference. Wow. So the bank, yes, will talk to an executor. No, will not talk to an administrator.
So potentially...
I can't say they won't. It's up to the bank. The bank might talk to an administrator, too.
So just going back to what kind of started all this, just play along. The executor, someone was named the executor of that estate with all these heirs. Do you think the bank potentially would have allowed them to sell it just as the executor if they were the named executor out of the will and gone through probate and appointed?
You're talking about the one that had 24 people?
Yeah.
No, because there was not an executor over all 24.
Gotcha.
See what I'm, now, if the original owners that these 24 people were related to had a will and appointed an executor, it really wouldn't have even gotten to the point of belonging to those 24. The executor, if the will says, usually the will will say, I appoint my executor and she or he has all the powers in Virginia over my real estate, then the executor 100% should sell that property, pay off the mortgage, and then their job is to, after bills are paid, to divvy out the money.
Wow. That could have been. So, bottom line, folks, please get your estates in order. I can tell you, and this could be an hours-long conversation with Lynn, but I won't hold her. And I will. And again, please tell everybody your information, how to get in touch with you, because I want them to come to you, because I know it's crazy. I'll put these videos out. People might not respond to the videos, but then I get all of these messages behind the scenes or text messages or, hey, how can I get in touch with that person?
So it's Lynn Tucker. I'm with Dankos Gordon Tucker here. My direct phone number, 804-377-7424. And my email is ltucker at, of course, Dankos Gordon is hard, DANKOSGORDON.com. So email or phone, probably email's a little better way to get in touch with me, just because it's hard to get to all the phone messages, but I'm checking email all the time.
Right.
So,
well, I thank you.
Okay, my pleasure.
You know, like I said,
I like to educate people.
Yeah, I know.
I very much do.
We've kind of had that brief conversation before, and not to say that I won't do something larger and in person with some folks. Maybe one day we can do like a lunch and learn or something like that. And we'll talk about that. But I just know that estate planning is so important, so many people are not doing it,
and there's so much misinformation.
Yes,
I just like to be a myth buster.
Right. Well, people jump on the internet and they think, I saw something on
Google
YouTube.
It, I know.
Yeah,
but everyone's facts are different. That's why I tell them you can't Google it or listen to your neighbor, because everyone's facts are different. Everyone's goals are different. So your plan should be different.
Well, that about sums it up. Okay. Thank you again.
You're very welcome.
Happy Monday to you. I appreciate you. Y'all stay tuned. I'll bring somebody else. See you on the next one. See y'all later.